Are there any other votes? Announce the results.
Ayes 104, noes 0.
The bill is passed.
Assembly 2658A, Calendar 121. Mr. Weprin, an act to amend the executive law.
An explanation is requested, Mr. Weprin. One moment before we begin. Members, we are on debate. Please settle down. Members that are in the aisles, take your seats. Conversations take to the rear.
Thank you, Mr. Speaker. This bill would amend the executive law in relation to requiring counties to maintain a confidential registry of people of all ages with disabilities for evacuation and sheltering during disasters. In times of disaster, as we saw during Hurricane Sandy, it is vital that emergency service personnel are able to locate persons with disabilities who may have difficulty evacuating. While this bill directs counties to maintain a registry, it is of course voluntary by the person with disability to join those in the registry, and they may request their information at any time. This registry is, as I mentioned, is confidential and can only be assessed by the relevant county, state, or federal agency. This bill will greatly aid localities in preparing for and responding to disasters. Creating a standardized registry in counties will allow information to be sent out quickly and efficiently in an emergency and will protect persons of all ages with disabilities.
Mr. McKevitt.
Sponsor, yield for a few questions, please.
Mr. Weprin, will you yield?
Gladly.
Mr. Weprin yields. Mr. McKevitt.
Could you give some guidance as to exactly what type of information will be in this registry? I know you've said the purpose of the registry is to aid them in finding those who would need assistance, but what type of information do you contemplate would have to be in this?
Well, basically just names, addresses, information, anybody that would need extra assistance. Obviously, you could detail your disability or not detail your disability, but basically let the local county or city or registry know that there is a person that might need additional assistance in evacuating.
I mean, information such as whether a person's on a respirator or not, because that would certainly entail, a person would need emergency electricity at a time to make sure they're breathing. Would that be other types of information that
yes,
should be
that would be a very important piece of information.
Right, because I think just one thing that some of the counties have brought up is that certainly the point is to have some sort of uniform directory, but the bill just doesn't give guidance as to exactly what should be there and what's not. I suppose one way of looking at it is to really let them on a county-by-county basis, let them tailor that directory, but then instead of having a uniform directory, you may have something which is even less uniform than what we have today, which is nothing.
Part of the issue raised by the disability community, there were a number of people that didn't want to be stigmatized because they have a disability, but clearly I think it should be up to the local registry, the local municipality that's putting together the registry as to what information they should ask for, specifically dealing with an issue as you just raised.
Right. Just one interesting thing, at the end of the bill on page 2, lines 50 through 54, it talks about the liability of a county for any claimed upon the exercise of the performance in relation to carrying out a local disaster plan. And currently, a county is not liable for any good faith exercise, yet this bill adds the word reasonable good faith exercise. And I'm just curious as to the word why reasonable was put in there when right now it's only a good faith exercise would allow the municipality not to be liable for its actions.
Well, I think it was just, a reasonable person standard was put in because I think that was, what people felt was reasonable. I think it just clarifies a reasonable person standard.
The only thing I would argue is that instead of actually clarifying it, I think it maybe opens up to a great extent because right now, as long as a municipality or county can show they did a good faith exercise, certainly during a natural disaster, there could be a lot of interpretations as to whether their actions were reasonable or not. Again, you have limited resources. Again, there may be flooding. So again, just a concern I have is that by putting the word reasonable in there, you're doing a great opening up of liability, where right now a county wants to show they did the best good faith basis they could do based upon disaster at a time. Just something to consider for future drafting of the bill.
Yeah, we would consider that. And as you know from our days at Hofstra Law School, the reasonable person standard is well defined in many places in the law.
It's well defined, but I guess as Dean Twersky and I would also indicate, there's a lot of litigation in there as to whether that reasonable does apply in certain situations or not. So, absolutely.
Well taken.
Just one other point I'll mention is that for a number of years this bill had passed quite unanimously in this House until 2010 it got to Governor Patterson's desk, and he vetoed it based upon the grounds that this would actually be an unfunded mandate to many of our counties. And I'm just curious whether there's any type of funding mechanism in your bill or any contemplation to assist them in this type of directory for the future.
Well, you know, there is a lot of federal money that has been, taken place in the event of disasters, and this is certainly something that a local municipality could apply for under FEMA and other, federal money specifically for this. But if you remember correctly, at that point in 2010, Governor Patterson was vetoing any bill that had any fiscal implication because we had a $10 billion deficit at the time.
Okay. Thank you. Mr. Speaker, on the bill.
On the bill, Mr. McKevitt.
Certainly, I think the sponsor has an excellent intent here. You want to make sure that there is people within a directory in case a disaster occurs, that, again, the first responders will know where they are and what situations they may need assistance. But I'll just point out that this is another unfunded mandate on our counties, of which the state could go and step up and provide the funding. And if we were to implement something like this, I would suggest that the state does step up to the plate and give those municipalities and those counties the funding to enable this to happen. And just one other point I have is, certainly you want to go and look at a reasonable standard to make sure as counties go forth and follow forth their plan of providing assistance. My concern is that you could be opening up liability to a great extent, causing further financial harm to our government. So, again, I do have a good intent for the bill, but there are a number of concerns which I think my colleagues should take into account when they're voting on this bill. Thank you.
Thank you, sir. Read the last section.
This act shall take effect January 1st.
The clerk will record the vote. Are there any other votes? Announce the results.
Ayes 85, noes 33.
The bill is passed.
Assembly 3450, Calendar 504, Mr. Wright, an act to amend the social services law.
An explanation is requested, Mr. Wright. Shh. Ladies and gentlemen, please.
You're more than happy to, Mr. Speaker. When determining whether or not a person has a disability, for the purposes of assigning an appropriate work activity, this bill would line the current SSI standards with public assistance, allowing the treating physician's opinion to be controlling.
Mr. Goodell.
Thank you, Mr. Speaker.
Members, may we remind you we're on debate. If you don't have to be in the aisles talking, I'd ask that you please take your seats. Members, proceed, Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
As soon as the photographer gets out of the way between the two of you.
I would be more than happy to yield, Mr. Speaker.
In the meantime, make sure you smile for the photographer.
Well, depends on who I'm debating.
Well, I certainly wouldn't want to spoil a good photo, but I do have a few questions, if you
Yes,
would
sir.
mind. Under your bill, you say that with some exceptions, the healthcare practitioner's disability determination would be binding. What do you mean when you say a disability determination? Is that both the medical and vocational determination?
Just medical determination, Mr. Goodell.
Is there anything in your bill that makes it clear that it does not apply to the vocational aspect of a disability determination?
Well, current law, people go through the employability plan, and that's what actually determines that.
Under current law, am I correct? If the Department of Social Services finds that the medical information is adequate, they can accept it right on the spot. There's no need for any further review, correct?
That sounds correct to me, Mr. Goodell.
But if they find the information is insufficient, the documentation is insufficient on the medical level, then under current law, the Social Services Department can ask for a further medical evaluation. Would you agree that a further medical evaluation is appropriate if the current documentation is insufficient?
Sounds correct.
And in order to do that further medical evaluation, they refer to an independent healthcare practitioner that's been certified by the state as being competent and qualified to do that kind of evaluation.
Well, I mean, there could be an argument made that a practitioner that works for the state of New York may or may not be all that independent.
Well, they're not being paid for by the local district, correct?
They're being paid for by the state.
I mean, they're not certified by the local district. It's a separate certification by the Office of Disability Determinations, right?
They're certified by the state. Isn't that what you're asking?
Yes.
So I'm just making the argument, Mr. Goodell, that when they're certified or work for the state, they may or may not be considered independent.
Is there any obligation under your bill that the individual healthcare provider be certified by anybody?
Well, I mean, if they're a doctor or a physician in the state of New York, I presume that there's a presumption that they are licensed to practice medicine within the state of New York, so there is that degree of certification.
Then under current law, if there's insufficient evidence, then the Social Services Department refers it to a medical practitioner for another review. That review has to be done by somebody, as we mentioned, that's certified. They're required by law to review all the medical records. So they have all the same medical records as a healthcare provider. And then they render a medical decision, right?
Correct.
And the last time I checked the data, roughly 45% of individuals who would otherwise be eligible have some sort of disability determination. Is it your belief that the number of people who are disabled in New York State and collecting public benefits is higher than 45%?
I would argue yes.
And do we have any documentation that indicates that these independent evaluations are incorrect? As you know, after you do the independent evaluation, you have a right for a fair hearing. How many fair hearings result in a decision overturning the local social services district on these medical evaluations?
You're asking me how many fair hearings are overturned?
Yes, how
I
many
have
medical...
no idea. I don't have that answer at my fingertips.
And even if they don't like the fair hearing, an individual can appeal the disability determination to court under an Article 78 proceeding, right?
I did not hear the question. I really did not.
Even if an individual disagrees with the independent evaluation, takes it to a fair hearing, loses at the fair hearing, they can still file an Article 78 in court and have the whole thing reviewed by a court, right?
Sure. I mean, that could be an option, sure.
And how many people do that, Mr. Wright?
I don't know, Mr. Goodell.
The annual report...
What the bill is trying to do is we're trying to prevent that very situation that you're talking about.
Now, the federal guidelines, which you reference in your memo of support, you say your bill would bring us closer to the federal guidelines. But the federal guidelines expressly state that the medical determination by a practitioner is not a disability determination. Is there anything in your bill that makes that clear?
There's nothing in this bill that prevents anyone from making a medical determination.
In fact, the federal guidelines are very clear. It says, and I quote, "A statement by a medical source that you are, quote, disabled, close quote, or, quote, unable to work, close quote, does not mean that we'll determine you're disabled." That's on the federal standards. But there's nothing in this bill that makes that distinction, correct? Because your bill says that the individual who is seeking public benefits, his own physician's determination is final and binding as to disability, which seems to be directly contrary to the federal legislative or regulations.
We're talking about in terms of medical conditions only, Mr. Goodell.
Okay.
Only.
Thank you. I appreciate your comments on the bill.
Thank you.
Thank you, Mr. Wright.
On the bill, Mr. Goodell?
Under the current system we have, if someone wants to be exempt from any work requirements and be able to not participate in job training or not participate in work experience, they can become exempt from those requirements or those opportunities, depending on your perspective, if they're disabled. And under our current law, the system is a very carefully designed system of checks and balances. The individual says, I should be relieved from any obligation to go to work because I'm disabled. Here's my doctor's information. If that information is sufficient, it's the end of the discussion. They're granted disability status. If it's not sufficient, then the current system allows the Department of Social Services to require an independent medical evaluation. by a physician that's been certified by the state, a separate certification for that type of evaluation. And they are required to review all the medical records. So all the information is out front. And if the applicant still doesn't agree, they can go to a fair hearing, and they can have an administrative hearing officer evaluate whether or not they should be entitled to collect public benefits without engaging any job training or employment experience or anything else that would help them get out of poverty. And if they're still not happy, they can file a court action, and they can review it in court. And it should be no surprise to any of us in this room that the number of fair hearings that are overturned in court are virtually zero. The Dictionary of Occupational Titles lists over 12,000 occupations. That's been replaced by ONET, which only lists 974. My point being, you can be a great physician. You could be the world's foremost podiatrist. You could know everything there is to know about feet and not know much at all about which of those 12,000 jobs you would be eligible for and could work for and do a great job in, regardless of the condition of your feet. The federal guidelines recognize that. The federal guidelines say, yeah, we'll take into account what your physician says, but whether you're disabled and unable to work is a vocational decision. And therefore, we, with vocational experts, will make the determination whether you're disabled. The current system we have now is the right checks and balances. We, as a legislative body, want to make sure that people who are disabled are properly classified that way. Our system guarantees that. At the same time, we have an obligation to protect the taxpayers from those few people that would like to collect money without being justified to collect it. And that's why we don't turn to the hand-picked physician from the applicant and take their word as the gospel, even when their medical documentation is insufficient. That's why, to protect the taxpayers, we ask for a separate independent evaluation. And that's the way the system should work. We should ask for independent evaluations to protect the taxpayers. Now, it should be no surprise to us that all of our counties association, the NYSAC Association, is opposed to this because of the cost and because it puts the fox in charge of the hen house. It puts the applicant's hand-picked physician in charge of who gets taxpayer money rather than an independent certified physician. And likewise, the City of New York Office for the Mayor is opposed to this, pointing out it's an unfunded mandate that will cost the city, they estimate, over $6 million a year. So I think the current system requires us to read all the medical reports produced by the applicant's physician and carefully consider all those medical reports. The best system is one where you have an independent checks and balances, where we're balancing the needs of the applicants against the protection needed to be afforded to the taxpayers. Unfortunately, this bill doesn't do that, and therefore I would recommend we vote against this bill. Thank you, Mr. Speaker.
Read the last section.
This act shall take effect on the 90th day.
Clerk will record the vote.